Eleanor Vance, 74, retired mechanical engineer with a 38-year career designing industrial equipment, was cleaning out her attic on a Saturday in October, sorting through boxes she hadn't opened in decades, when she found a spiral-bound notebook with a faded cover, dated in her own handwriting, Design Ideas 1995. She opened it expecting nostalgia, old sketches from a creative period in her career, half-formed, concepts she'd never pursued. What she found instead made her sit down on the dusty attic floor and read. For nearly an hour without moving, Eleanor turns to a page roughly 2/3 through the notebook, a detailed mechanical sketch, dual spring tension mechanism, rotating cam assembly, careful annotations in the margins about material selection and a recurring engineering problem she'd been wrestling with that year: reset time between operational cycles. Eleanor, I want to describe the exact feeling of looking at that page, because it was not immediate recognition. It was something stranger, a slow building, disorienting familiarity, the feeling of looking at something you know intimately but cannot immediately place. And then, within perhaps 30 seconds, the placement arrived with the force of a physical blow. This was my son's invention, the one on the cover of 3 business magazines, the one business schools now teach as a case study in disruptive innovation. The one that had made my son Daniel, 44, a multimillionaire and something of a minor celebrity in engineering and entrepreneurship circles. I was looking at it in my own handwriting, dated 24 years before his patent filing. Eleanor, still sitting on the attic floor, calls her daughter Margot, 41, before processing the discovery. Further, Margot, Mom, what's wrong? You sound strange. Eleanor, I found my old design notebook from 1995. Margot, there's a sketch in here. The dual spring mechanism. The exact configuration is identical to Daniel's patent. The one his whole company is built on. A long pause on Margot's end. Margot, Mom, are you sure? I mean, could it just be a similar idea? Engineers solve similar problems in similar ways sometimes, don't they? Eleanor, Margot, I am a mechanical engineer with 38 years of experience. I know the difference between a similar solution and an identical one. This notebook has my exact measurements, my exact material notes, even a margin note about reset time that reads almost word for word like the language in his patent's abstract. This is not similar. This is the same design. Eleanor sits with the notebook for the rest of the afternoon, and a specific memory begins to surface, one she had not thought about in over 2 decades. I remembered, slowly, and then all at once, showing this exact sketch to Daniel. He was 19, home from his first year of engineering school, full of energy and ideas. I remember sitting at the kitchen table with him, this very notebook open between us, walking him through the mechanism, the problem it solved, the reason I'd never pursued it commercially. I was deep in a demanding corporate engineering role at the time and didn't have the bandwidth for an independent invention. I remember saying to him, almost exactly, someday, maybe we'll build this together. I remember him nodding, excited, asking questions about the cam assembly that showed real understanding. I remember feeling proud that my son was engaging with my work so seriously. I had completely forgotten that conversation for over 20 years. Daniel, apparently, had not forgotten it at all. Over the following days, Eleanor found herself reconstructing, piece by piece, the full arc of Daniel's relationship to her old notebook. Not just the single kitchen table conversation, but a pattern of small moments across years that, viewed individually, had seemed unremarkable and viewed together now seemed devastatingly clear. The memory that disturbs me most, now that I'm looking at all of this together, is the afternoon in 2008 when Daniel offered to help me organize the attic. I remember being touched by the Gesture at the time, my busy, successful son taking an afternoon to help his retired mother with manual labor. I remember he spent a long time near a particular stack of boxes, and when I asked what he'd found, he said, "Just some of your old work stuff, Mom, nothing exciting," and moved on to help with something else. I did not think about that exchange again for over a decade. I think about it now and wonder whether that was the afternoon he located the notebook, photographed the relevant pages, and quietly returned the notebook to its box, leaving me with no reason to ever suspect anything had been disturbed. Mom, if this is true, he didn't just borrow an idea. He spent 11 years planning around it. He waited until you'd be unlikely to ever connect the dots, built an entire company on it, and let you watch him become famous for your invention without ever telling you. Eleanor, I keep trying to find an innocent version of this story, Margot. I keep trying to imagine that he genuinely forgot the notebook existed, that he arrived at the same design independently through some kind of subconscious memory of a teenage conversation. But the more specific the details get, the material notes, the margin language about reset time, the harder that innocent version becomes to believe. Margot, what are you going to do? Eleanor is quiet for a long moment, looking at the notebook on her kitchen table. Eleanor, I'm going to call a patent attorney before I call your brother. I want to understand exactly what I'm looking at before I have a conversation. I can't take back. Eleanor retained patent attorney Victoria Reyes, who specializes in inventorship, disputes, a niche but consequential area of intellectual property law dealing, specifically with claims that are patents named, disputes, a niche but consequential area of intellectual property law dealing, specifically with claims that a patents named inventor is not, in fact, the true originator of the claimed invention. Victoria, Mrs. Vance, I want to walk you through what we're looking at very carefully, because inventorship disputes are notoriously difficult to win unless the evidence is exceptionally strong. Courts are skeptical of late-arriving claims, especially family disputes that could be read as opportunistic. We need ironclad, contemporaneous documentation, and we need it to be more than just similar to the patented design. Eleanor, I believe what I have is significantly more than similar. I'd like you to review the notebook directly against the patent filing. Victoria spends 3 weeks engaging a forensic document examiner to authenticate the notebook's age and in composition, alongside a technical patent analyst who conducts a detailed side-by-side comparison of the 1995 sketches against Daniel's 2018 patent application. Victoria, Mrs. Vance, I want to be very direct with you. In 22 years of practicing patent law, I have rarely seen a comparison this clean. The forensic document examiner has confirmed the notebook's ink and paper are consistent with 1995 manufacture, ruling out any possibility this was fabricated after the fact. The technical comparison shows not just conceptual similarity but specific, granular details, material selection language, problem framing language, even the viewing angle of the diagrams. That would be extraordinarily unlikely to occur independently. Eleanor, what does that mean for a legal case? Victoria, it means we have a strong inventorship claim. Under patent law, the person who actually conceived of the claimed invention is the rightful inventor, regardless of who files the paperwork. If we can demonstrate, with this level of evidence, that you conceived this invention in 1995, and that your son had access to and almost certainly used your documented work, we have a credible path to correcting inventorship on the patent itself, which would transfer ownership and all associated rights and profits to you. Eleanor absorbs this with a complicated mixture of vindication and grief. Eleanor, I need to talk to him directly before we file anything. I need to give him the chance to explain, even though I'm having an increasingly difficult time imagining what explanation could account for this level of detail. Eleanor invited Daniel to her home for what she described in the invitation only as an important conversation, deliberately vague, wanting to observe his unguarded reaction rather than give him time to prepare a defense in advance. Eleanor places the 1995 notebook on the coffee table between them, open to the relevant page before Daniel has even sat down. Daniel's face changes the moment he sees it, a flicker of recognition, quickly suppressed, that Eleanor, watching closely, does not miss. Daniel, Mom, what is this? Eleanor, you know exactly what this is, Daniel. I found it cleaning the attic. I'd like you to explain to me how a sketch I made in 1995, in my own handwriting, ended up as the foundational design of your patented invention 23 years later. Daniel is quiet for a long moment, his composure visibly working to reassemble itself. Daniel, Mom, I think you're seeing connections that aren't really there. Engineers solve similar mechanical problems in similar ways all the time. This is a pretty common principle in spring tension design. Eleanor, Daniel, the material notes in my margin say almost exactly what's in your patent specification. My note about reset time reads nearly word for word like your patent. Abstract, I am not seeing a common principle independently arrived at. I am seeing my own design with my own annotations that you had direct access to as a 19-year-old. And, again, I believe, during a very specific afternoon in 2008 when you offered to help me organize this exact box of materials. Daniel, Mom, even if some of this looks similar, you never built it. You never patented it. You never did anything with it for over 20 years. I'm the one who actually developed it into a real, viable, manufacturable product. That has to count for something. Eleanor, developing an invention into a manufacturable product matters. Daniel and I don't dispute that you did real engineering work to bring this to market, but that is a different question from who originally conceived the invention. The law distinguishes between those two things very clearly, and I have just spent 3 weeks confirming with a patent attorney and a forensic document examiner exactly which side of that distinction we're on. Daniel's face goes pale. Daniel, you hired a lawyer before you even talked to me. Eleanor, I hired a lawyer to understand what I was looking at. Daniel, because I did not trust myself to have this conversation without first knowing whether my eyes were deceiving me. They were not. I am giving you, right now, in this conversation, the opportunity to tell me the truth, before this becomes something neither of us can take back. Daniel sits in silence for a long, devastating moment. Daniel, I found the notebook in 2008. I'd been thinking about your sketch on and off for years, honestly. I told myself at first that I was just going to study it, understand the engineering, maybe ask you eventually if I could develop it with you. And then time passed and the company started taking shape around other ideas. And eventually it just be ECAME mine. In my head, I know that doesn't excuse anything. I'm not proud of how this happened. Eleanor, Daniel, I said to you, when you were 19 years old, someday maybe, we'll build this together, Daniel. Not someday you take this from a box in my attic and build an entire company on it without ever telling me. Do you understand the difference between those two sentences? Daniel, I do. I understand it now in a way I think I managed not to understand for a very long time. Eleanor, I am going to pursue a legal correction of the patent's inventorship. Daniel, I want you to hear that directly from me, not from an attorney's letter. I do not know yet what that means for your company, and I want you to know that is not a consequence I am pursuing out of malice. It is simply the consequence of what you did. Eleanor's lawsuit, formally a petition to correct inventorship under federal patent law, proceeded over the following 10 months. Daniel, despite his private admission to Eleanor, contested the claim through his own attorneys, a decision driven. His lawyers later suggested in filings by the company's board of directors, who had enormous financial exposure tied to the patent's validity and ownership. Victoria Reyes presents the forensic document examiner's testimony, establishing the notebook's authentic 1995 origin, followed by the technical patent analyst's detailed walkthrough of the design comparison. Victoria, Doctor, in your professional opinion, what is the likelihood that the specific combination of design elements, the dual spring mechanism, the precise material specification, the framing of the reset time problem in nearly identical language could have been independently conceived by two different engineers, 23 years apart, without one having access to the other's work? Technical analyst, in my professional assessment, that likelihood is extremely low. The specificity of the overlapping details, particularly the matching margin language about reset time inefficiency, which appears in both the 1995 notebook and the patent's abstract in nearly identical phrasing, strongly suggests direct derivation rather than independent invention. Daniel, under oath, is questioned directly about his access to the notebook and the timeline of his company's development. Opposing counsel cross-examining Daniel, Mr. Vance, did you have access to your mother's 1995 design notebook prior to filing your patent application? Daniel, I saw the notebook once, briefly, when I was a teenager. I don't recall studying it in detail. Opposing counsel, Mr. Vance, I'd like to direct your attention to a sworn statement you provided during discovery, in which you described a 2008 incident where you, in your own words, spent time reviewing the notebook's contents while helping organize your mother's attic. Would you like to revise your testimony? Daniel, having already provided a more candid account during discovery under the advice that perjury carried its own severe consequences, is forced to confirm the earlier, more detailed admission. Daniel, yes, I reviewed the notebook's contents in 2008. I did study the design. Judge, the court finds, based on the totality of evidence presented, the authenticated 1995 notebook, the highly specific and improbable overlap in technical language and design details, and the defendant's own admitted access to the original documentation, that Eleanor Vance is the true and original inventor of the mechanism claimed in Patent No. 10X. The court orders the patent's inventorship corrected to reflect Eleanor Vance as sole inventor, with all associated ownership rights, licensing revenues, and profits derived from the patent to be transferred accordingly. The court further orders an accounting of all revenues generated since the patent's grant, for purposes of determining appropriate restitution to the rightful inventor. The courtroom is silent. Daniel does not look at his mother as the ruling is read. Eleanor, I did not feel triumphant hearing that ruling, though I want to be honest that I felt something like relief, the relief of having an objective external authority confirm what I already knew to be true, after weeks of wondering whether I was somehow imagining or exaggerating what I'd found in that attic. What I mostly felt sitting in that courtroom was an enormous, complicated grief for the son I thought I had set against the son who had apparently been capable of this for over a decade. Daniel's company, built almost entirely around the patented mechanism, faced an immediate and severe crisis the moment the inventorship ruling became public. Investors, business partners, and licensing clients all required clarity on a question the ruling had just thrown into chaos. Who actually owned the foundational intellectual property the entire business depended on? With Eleanor now the legal owner of the patent, she holds the leverage to determine the company's future. whether to license it back to Daniel's company under new terms or decline entirely. Eleanor, working with Victoria, ultimately decides not to grant a licensing agreement to Daniel's company, citing both the egregious nature of how the IP was obtained and her own discomfort continuing any business relationship with her son under the circumstances. Without rights to its core mechanism, Daniel's company collapses within 4 months. Investors withdraw, the product line is discontinued, and the majority of the workforce, nearly 60 employees, lose their jobs. Daniel, Mom, 60 people lost their jobs because of this. I know I did this to myself. I'm not blaming you. I just want you to know the scale of what collapsed. Eleanor, I am genuinely sorry for those 60 people. Daniel, I want you to understand that their job losses are a consequence of the choice you made over a decade ago, not consequence of my decision to seek what was rightfully mine. I did not build a company on a stolen foundation. You did. The court-ordered accounting determines that Daniel's company generated approximately $5.2 million in profits attributable to the patented mechanism over its commercial lifespan. Eleanor is awarded the full amount in restitution, along with ongoing rights to any future licensing of the design. Daniel, whose personal assets are significantly tied to the now collapsed company, faces substantial personal financial consequences as well, including the loss of his equity stake, which had been his primary source of wealth. Eleanor, I want to be honest about the complexity of receiving that money. It did not feel like winning a lottery. It felt like being formally, legally compensated for something that should never have needed compensating in the first place, the theft, essentially, of both my invention and over a decade of my son's honesty. Eleanor, working with a financial advisor and her own clear sense of purpose, decides how to allocate the restitution. Financial advisor, Eleanor, with $5.2 million. You have considerable flexibility. Most people in your position would understandably keep the majority for security and enjoyment after a difficult ordeal like this. Eleanor, I want to keep enough to retire completely comfortably. I've earned that, and I intend to enjoy it without guilt. But I want the majority of this to go towards something meaningful. I spent 38 years as an engineer who rarely saw women entering or staying in the field. I want to fund scholarships and mentorship programs for young women pursuing engineering degrees, particularly in mechanical and industrial engineering, where the gender gap remains significant. Eleanor establishes the Vance Engineering Scholarship, ultimately funding it with approximately $3.80 million of the restitution, retaining the remainder for her own comfortable retirement. Eleanor and Daniel's relationship remains, 18 months after the ruling, deeply strained but not entirely severed. They speak occasionally, carefully, without the warmth that existed before 2008, though Eleanor has chosen, for her own peace, not to close the door entirely. Margot, do you think you'll ever fully reconcile with him? Eleanor, I don't know, sweetheart. I think about that conversation from 1995 often. Someday maybe we'll build this together. I think the tragedy of all of this is that the sentence was an invitation, and he could have simply said yes at any point over those 11 years, and we actually would have built it together, properly, honestly. Instead, he built something extraordinary on a foundation of theft and secrecy, and now neither of us has what we might have had if he'd simply told me the truth from the beginning. Margot, that's a sad way to think about it. Eleanor, it is sad. It's also, I think, the most honest way I know how to think about it. At the inaugural Vance Engineering Scholarship ceremony, Eleanor presents the first award to a young woman, Priya Natarajan, 19, beginning her mechanical engineering studies. Eleanor, I want to tell you something briefly about why this scholarship exists. I spent my career designing things, solving problems, building solutions that mattered. Late in my life, I learned that even the most careful, accomplished work can be taken from you if you're not protected, and that the people you trust most are not always who you believe them to be. I want you to leave here today with two things: confidence in your own ability as an engineer, and the wisdom to protect your work. Document everything, and never assume good faith protects you the way good documentation does. Priya accepts the scholarship, visibly moved, unaware of the full personal history behind Eleanor's words, but sensing correctly that they came from somewhere real. Eleanor Vance is 75 now, enjoying a comfortable, secure retirement and the quiet satisfaction of watching the Vance Engineering Scholarship fund a new generation of young engineers. Each year, Daniel has rebuilt a smaller, more modest career in industrial consulting, his name no longer associated with magazine covers or business school case studies. If this story found you, subscribe. Leave a comment. Have you ever discovered that someone close to you took credit for your work? And what does Eleanor's original sentence, "Someday maybe we'll build this together," mean to you, knowing how the story actually unfolded? Document everything. Protect your work. We'll see you in the next one.